Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the jail calendar for October 21st of 2025. This is courtroom 304 of the Clayton County State Court. I'm going to call the calendar in a moment, but I do understand we have someone here from Wheeler. So if we could take that case first. We have a arraignment calendar and we have the jail calendar, and I'm not sure which calendar this is on.
It should be on the arraignment calendar, Your Honor.
All right. Good morning, Mr. Castaneda. It's been a minute.
Yes, it has. Good morning.
Good to see you. I've seen your brother more than I've seen you.
Oh, man.
Good morning, Your Honor. Your Honor, which case did you say we're taking first?
The case on the arraignment, what is his name, Mr. Castaneda?
His name is Quentin Ford Willis.
Oh, okay. Last case on the arraignment calendar, Mr. Willis. Mr. Willis is in Wheeler, so we want to go ahead and get thanks thanks to the individuals who kind of make it happen so that we can get them here. But we want to go ahead and make sure we get his case taken care of first. So this is Mr. Willis is before the court for battery, family violence, simple battery, family violence, simple battery, and theft by taking. And Mr. Castaneda, Johnny Ramirez Castaneda, is representing him on the 2023 CR 03194 case. All right. Mr. Castaneda, had you already talked to the state about this case?
No, Your Honor. I reached out and I was in communication. Let me see here.
I guess you may have spoken to our previous solicitor, but we have Ms. Bing now. Did you want to, Mr. Brooks, should we do a breakout room so one of y'all can talk while I go over the calendar with the other solicitor?
That's fine, Your Honor.
All right. So did you want to be in the breakout room with Mr. Castaneda, or you want to give me to give that to Ms. Bing?
I can go in the breakout room, Mr. Castaneda.
Okay. All right. Thank y'all for the audible. I just would rather go ahead and get that done first in case we have any connection issues.
All right.
Your Honor, before I go into the breakout room, there is one matter that's on the jail calendar.
Yes.
Anthony Lamar Brooks. I think Your Honor may have previously sentenced him on a battery, family violence. So the case that's on the calendar actually is being prepared for a transfer.
Yeah. He was on probation for the previous battery case. So Mr. I don't know if this is Ms. Tortorello or Mr. Lynch, but yeah, now I see he has another battery case, 2025, and the petition had already been transmitted to me for today for the previous battery case that was closed on March 18th of 2025.
Your Honor, are you speaking about Mr. Anthony Brooks?
Yes.
Okay, the first case was a simple battery, family violence, Your Honor. I'm not sure if
No, he has a battery on his battery, family violence on his history as well. Ms. Bing has the file.
Okay, so the petition would have been for the simple battery before me, but my understanding is he has a previous battery, and I was not sure if this was the same victim that he was not supposed to have contact with.
It is, Your Honor.
Okay, that's what I was thinking.
Your Honor, so he had, I believe, the probation requirements were no violent or harassing contact.
From what I'm understanding from reading the petition, that may not have been it have been outside the bounds of what I asked him to do. So we can have a hearing if you want to on the petition, but if there's a previous family violence battery, then it's ripe for transfer.
I will conference with my client about exactly whether or not he would like to have an evidentiary hearing for his probation revocation, Your Honor. We're still not quite sure yet what his decision will be. So I appreciate
Well, that's fine. Okay, but let me just be clear that whether or not he has an evidentiary hearing on the petition is not going to change whether the whether the second case is ripe for transfer if it is the result of him having a previous conviction for battery family violence.
I understand, Your Honor.
All right, so just make, because he may not be clear about that, just make that clear to him, that one has no bearing on the other.
Yes.
All right, thank you.
You're welcome.
All right, so I set up the breakout room for Mr. Brooks and Mr. Mr. Castaneda, so you all can go in at will. I'm going to go ahead and go over the arraignment calendar and the jail calendar and get announcements, and then we will move forward with that. All right, let's start with the arraignment calendar. Donald Allen Campbell. That's a Lister Holton Dennis case.
Your Honor, that's, I believe, Mr. Lynch has been speaking to him. Give me 1 second.
Okay, 1 second. Ms. Hemmings, thank you so much again for making this possible and working with us to get these, get people here for these hearings.
Remember you emailed Justin about it? He responded back. He said that we requested an eval and we lost track.
Your Honor, on Campbell, our understanding is that he was released a while ago from jail, but we never had contact information for him. We did do an eval order, and he was released on October of last year.
I'm sorry, I missed part of that. What was it?
So he was released a while ago, and we never had contact information for him when released.
Mr.
And
Campbell?
he was released on October of last year. We did do an eval order for him to get evaluated. It was signed off, but
I think he was just released from jail while the eval was pending.
Yeah, I'm not sure who put him on the schedule, but I believe he was scheduled for a status hearing because it was our understanding that he was still in the process of trying to get an eval.
yes, Your Honor, and we do not have, unfortunately, we don't have contact information or where he is at right now.
Okay, so a bench warrant bond forfeiture will be issued. All right, and that's Mr. Campbell has 2 cases. Kanan Blue Downer.
Keith Wiseman for Mr. Downer. He's on call and we have a pre-negotiated plea ready to go.
All right, Mr. Downer, we ready for the plea, Ms. Bing?
Sorry, I was on mute. Whether we're ready, yes, we're ready.
All right, so Mr. Downer, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus Kanan Blue Downer 2024 CR 09928 for speeding count 1 and careless driving count 2. You're represented by I'm sorry, your last name again, sir? Wiseman. Okay, because it's different from what I have on my calendar.
He worked with the same firm as Ben Mozingo.
Okay, so Mr. Wiseman, and he's present with you for this hearing. What is your client plea to the offenses before the court, Mr. Wiseman?
It's a NOLO to the speeding, and then the careless and reckless was to be merged into the speeding.
Okay. All right, so by entering a plea of NOLO to count 1 and count 2 will merge, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any evidence or testimony against yourself. And Mr. Downer, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis and recommendation, please, Ms. Bing.
Yes, I'm sorry. Could you hold for just 1 minute? I think.
I got it, Gary. I got it.
Oh,
It's
okay, thank you. I
these
didn't know if you were outside the break room or not.
officers on December 5th, 2023, officers with the Marl Police Department were doing traffic enforcement in the area of I-75 southbound. Officers observed a vehicle going at a rate of speed 124 miles in a 65-mile-per-hour zone. This all occurred here in Clayton County. State's recommendation he's pleading to both counts, Your Honor.
He's pleading to count 1, count 2 is merging.
Count 1 is a $500 fine.
All right. Mr. Wiseman, how long does your client need to pay the fine? The total with the surcharges is going to be $737.50.
Mr. Downer, when can you pay that?
I can pay it today.
Well, I give you 30 days because you're not at the courthouse. You can pay in person, you can pay online or by phone. But if you're all paying online or by phone, please be prepared to pay the entire thing. Plus, I guess some administrative surcharges that come with that. If you're going to come into the courthouse to pay it, we're at 9151 Terra Boulevard. You'll come to the second floor and you will pay at the window. Now, what I need from you is your email address. If you will chat that, you know how to use the chat function?
Yes, ma'am.
All right, so you're going to chat. You're going to click on the name that's in dark blue. You're going to chat your email to Miss Wright, Amanda, Amanda. Yeah, and then Wright, Ryte. So once you have sent her your email address. So now, Mr. Downer, can we talk about why you were driving a ambulance without driving an ambulance?
Yes, ma'am. If you don't mind me saying it, I was going to the dealership to actually have my car fixed. There was a cold air intake installed on my vehicle, but it was improperly installed. So previously throughout the day and the day before, my car had stalled on the roadway. I noticed that it was doing that when I was going at low rates of speed. In hindsight, and me being older now at 22 years of age, I realized I should have just called a tow and had it towed to the dealership. But I had to go to work that same day, and the officer seen that I was in my work clothes. I was just trying to go to the dealership though, where I bought the car from, just to get it fixed, and I was going to go the way to work. But I realized when I was keeping the car at a higher rate of speed, it wasn't doing the stalling, and that's when the Clayton County, I guess, radar me.
Okay, because it's hard to control the car at that high rate of speed. I was 21 once too.
Yes,
What kind of car we talking about, sir?
it was a Camaro. It was a Chevrolet
Oh,
Camaro.
I knew it was one of my muscle cars.
I
Mr. Downer,
apologize.
those cars
ma'am.
come with a lot of responsibility. Okay? A
Yes, ma'am.
lot of responsibility. You're young, and what I don't want is for you to end up in one of those horrific crashes that happens when people think that they can drive for everybody on the road. And by that, I mean, as much as you think you might be a good driver, imagine the scared little mama with her kids in the car who's looking in her rearview mirror and sees you coming. And, you know, if you're zigging or you're zagging or you coming real fast, and she gets nervous, and where you think you have an opening, she moves right into that opening. That mama is me. Okay. So
Yes,
what I'm
ma'am.
saying to you is you can only drive your car for yourself. And that's how accidents happen. And when we're talking about at those speeds, nobody walks away from that. All right. But
Yes,
as you said, you were younger. I get it. I always call your 20s your exploration phase. I actually call it your 20 stupids because we do really stupid things when we were in our 20s. But we want to start thinking about the long-term consequences of our actions. Okay.
Yes, ma'am. I completely agree.
All right. Okay. So you're going to, once you pay the fines and fees, you'll have I'll give you, are you here in town or are you somewhere else?
I live in
Are you
Douglasville.
in Georgia?
But yes, ma'am.
Okay. So, yeah, I'll give you 30 days in which to pay. And Ms. Wright is going to send you an email from the clerk's office that has all of the information in it and your sentencing sheet and the date by which it needs to be paid. Do not wait till the last minute to pay it. If you have not paid it on or before the last date or have not sought relief from the court for additional time, then an arrest warrant could issue, okay?
Yes, ma'am.
All right, now, Mr. Downer, don't disappoint me, okay?
I won't. Thank you so
All right,
much.
thank you, sir. All right, Mr. Wiseman, anything else?
No, that concludes my business, if I may be excused.
You may. You're free to go. Thank you.
Thank you, Your Honor. Appreciate it.
All right, so take care, Mr. Downer. All right. Thomas Lewis.
Your Honor, there's someone here with Mr. Lewis on the Zoom call.
Does he need someone?
Okay, here we go. Is this, this is not Thomas Lewis, correct? This is his brother?
That's right, Mr. Lewis. This gentleman helps his brother, Mr. Lewis, who has some medical issues.
So Judge, I'm not sure. So I know that, and I think his brother can attest to this. I know that he is in a group home. He is receiving counseling. And I think in the process of obtaining some documentation to show the state that he was initially released to go back to a group home. He does have some serious issues. I attempted
So,
to,
look, hold on, sir. Is he still in the group home?
Yes, ma'am. So right now he's in his daycare program. It's an adult daycare facility he goes to Monday to Friday from
Okay.
6 a.m. to 2. They provide him with things to do. He's also in therapy. Every Sunday he goes to church. And they got him on this right regimen of medicine.
Okay.
I'm not familiar with the name of the group home, but it's located in Jonesboro at 83 Lundy Lane.
You don't have to tell me you don't have to tell me the address because this goes out to everybody. I don't want anybody victimizing anybody who's in that group home. So yeah. Okay, Mr. Lynch, here's the thing. I'll need you and Miss Bing to work out whatever we're going to work out, whether we're going to bring him in for a status hearing in a couple of months to see if he is competent to resolve these issues, or whether we're going to do something else with respect to how he is going to be treated on this docket, because it appears that he's being stabilized in this facility. But we want to make sure that before we kind of disrupt his life and bring him back, that we have some thought process as to how this is going to be resolved.
yes, Judge, and I think that we could probably work out something. I know that I've had a little trouble getting face-to-face with Mr. Lewis, and some of that's on my end. But I think that,
Because if it's the group home who has to facilitate it, then you got to make sure that you have the person who's going to be able to do it. The timing has got to be right. So can we see if we can get that done?
Absolutely.
May I
Yeah.
say something?
Yeah, hold on just a second, sir. Before you do that, let me see if Mr. Brooks or Miss Bing want to weigh in. Mr. Brooks, so this gentleman has been kind of assisting his brother since he got out of jail with trying to get him stability.
Okay.
And he is kind of the only, one of the family members who's sort of trying to help him through this process.
Yes, ma'am.
And he's been in a group home. It appears that he's now getting the proper medical treatment, as well as any other kind of treatments that might help him to maintain his stability.
Mhm.
But I do want to say this, and I don't think I'm wrong, and I'll defer to his brother, but I don't think even with the medicine, I think there may be also some cognitive deficits that he has. Okay, I remember. I see, Mr. Lewis, I was paying attention. So even though he is getting stabilized from a mental health standpoint, I think that he may be one of those individuals who has an intellectual capacity that is less than his chronological age.
I understand. David Clefford, who is that to Mr. Lewis?
Is that the alleged victim?
Yes, the victim.
I believe that, if I'm not mistaken, I don't have it offhand, but I believe that's going to be an employee of one of the previous group homes, or either.
Gotcha. So he was a caretaker.
No, he was another patient.
Oh,
Okay.
no, patient.
Another
Okay.
resident. I mean, he was another resident at the group home.
Gotcha. And he's at a different facility now. Is that right?
Yes, sir.
I got you. Okay. So that being understood, it is my position that he may be lacking in the necessary mens rea for the case
Yeah.
to be prosecuted. That being said, the state will move to non-pros on the condition or understanding that Mr. Lewis is now in another facility and being stabilized in that facility and will continue in that capacity for the
Yeah.
foreseeable future. Is that right?
Yes, sir. May I say something?
Of course.
Yeah, well, let me explain first what Mr. Brooks is proposing. So Mr.
Okay.
Brooks is proposing to dismiss this case with the understanding that Mr. Lewis is getting the treatment that he needs and that he is being housed in a way that keeps him safe.
Yes, ma'am.
Okay.
I understand that, but on to Thomas' defense, he's receiving the wrong resources from his current waiver that he's on. He's not on a proper waiver. I've been trying to assist him in getting on the right waiver, but it's really has led to a dead end on my behalf. We have a family member that works for the police department that's been trying to assist, but he is also, like me, understands there's lack of resources for males in this type of situation.
Mm-hmm.
I understand.
Mm-hmm.
Let me ask this, Mr. Brooks, is there with the state, and I worked on the DFAC side, but I do know that there's an adult protective services, there's the not adult protect, but there's like a kind of like a social worker arm that helps adults who may not be able to kind of maintain themselves. And also I know that there's maybe some resources that are out there for managing his care, making sure he gets the right care. But I'm not sure, is that through the Department of Community Affairs or?
I
Yes, ma'am.
believe so. Mr. Lewis, have you have you been appointed as his guardian?
No. So Thomas does not have a power attorney. As far as like his case manager for his comp now waiver, I think he's on, is through visiting nurses. His caseworker name is Miss Salisbury.
Mm-hmm.
And but that the waiver he needs to be on is the DHD-DBB waiver.
So I
Because
can't give you legal advice, but I want you to consider going over to is he a resident in Clayton County?
Yes, I had all his paperwork set up. He receives mail here,
In
so
Clayton County. So I want you to go to the probate court and speak to somebody over at the probate court about what needs to happen for you to become his guardian to facilitate getting the proper waivers.
Okay.
Yeah, because
they can give you more resource advice about what needs to happen.
we have nothing that we can do from this standpoint other than make sure that we're not prosecuting him. But the probate court has, if nothing else, information about how best to direct you all to help him.
Okay.
Okay. And so, yeah, the probate court would manage that, whereas we are just trying to make sure that because he doesn't, and when Mr. Brooks says he doesn't have what is called the mens rea, it means that he doesn't have the ability to form the intention to do bad things because of the situation that he's in. But that's as far as we can go on this side. What the probate court does is they can make sure that they are helping to direct him, you all, in the proper way to get him the services that he needs, or to get to be able to apply for the services on his behalf because you have the proper conservatorship, guardianship, or whatever legal status. Okay.
All right.
All right then.
And now there's two different, what the judge just mentioned to you, conservatorship and guardianship. You may want to seek both. So one is for like over his finances or his business, and one is over his person. So when you go there, talk to him about both
dual power attorney.
Well, no, it's more than a power of attorney. So the guardianship would be you can direct his care, you can get information about his care, you can apply for things on his behalf to help him get care and to manage himself. The conservatorship would be if he is receiving, say, government funds for his, to help him to live, then you would be able to help manage his money so that it could be used best for his care. And so there's two things, but at the very least, you want to get, you want to talk to them about the guardianship, because that helps you to have access to his medical information and the ability to talk to people about his medical issues.
Okay.
All right. Thank you
Yes,
so
ma'am.
much, sir. I know so many people who, it's not that they don't love their person, it's just that they get fatigued from having to do all of the things that it takes to help provide care. And I know you've been hanging in there. And so I just want to thank you for making sure that you're always watching out for your brother.
Yes, ma'am. I'm trying, but the system is
The
it lacks a
system
lot of
is
people.
not easy.
It's
Not,
a lot of runaround. It really does.
man. I wish it were different. I tell you, I really do. But you are so right. It is not easy. But hopefully that through the probate court, you'll be able to at least get the information that you need.
Yes, ma'am. And I appreciate that. Thank you.
All right, thank you. And so you won't hear from us anymore unless something happens with his case. I mean, with him personally. Okay.
Okay. So to be clear, this case is dismissed.
Yes,
Yeah.
sir.
All right.
All right. Thank you.
Yes, ma'am. Thank you. Y'all have a good one.
You take
All
care.
right. You too. Take care. All right. So, thank you, Mr. Brooks, Mr. Lynch. If you would just make sure that you maintain the information on how to, contact anybody on Mr. Campbell's behalf. I mean, on Mr. Lewis's behalf, in case, we ever need that information. Okay.
Yes, ma'am.
All right. All right. Next is Wholeness Markland, Lorna Markland Wholeness, I think.
Okay.
And it looks like that case has been no pros.
Judge Hayward, hey, good morning. This is Larry Cohn. That case has been null pros.
Yes.
A few months back, we submitted a motion to seal or a petition to seal on that case as well. And I don't know what I mean, a long time ago, probably 30, 60, somewhere a good bit ago. What do we need to do to get that heard?
And you said a few months? Okay.
It's been more than 30 days. I know that.
Miss Kiera, if you could pull that for me from the electronic docket, and let's see what happened with that.
Yes,
Yeah,
ma'am.
I'm just going off memory on that. And I do have another
Yeah,
case on
the
the calendar
case was
too.
closed on August 5th, so that would have
Right.
been real quick.
Yeah.
Okay, so hold on. You have also Nancy Mayea.
Yes, and that diversion petition, everything's been done. She completed the whole program, and we're just waiting for, I'm not sure, it's Kevon Johnson or Kevon Johnson is supposed to submit the null pros. We've submitted the proof of the Operation 21. We've submitted the community service, and we're just waiting on that.
Mr. Brooks, you have any indication about that?
Yes, ma'am. I have that they have completed PTI paid, and due date is, I think it'll be processed by November 12th is the note that I have.
Okay. So by November 12th.
Right, everything's been done and submitted.
Okay, so we'll get between now and November 12th, we'll have the null process, what
Yes,
you're
ma'am.
saying.
Yes,
Okay.
ma'am.
Terrific. Thank you, Judge. And I'll sign off if I'll email your office about the other case as well. I don't want to hold
Yeah,
your
Miss
calendar up.
Kiera Powell, and if we have it and there's no objection, if it's something we can legally do, I don't see a problem with that.
Yes. Terrific.
All
Thank
right,
you, Judge.
thank you. Did we lose the Wheeler?
Oh,
Yeah, I think they must have misunderstood you, Honor. And we went to a breakout room. When I came back, he was gone. But for today's purposes, we're going to plead not guilty. I'm going
Okay.
to receive a discovery, and that way.
All right. Well, if y'all need to get them back on at some point, just let us know in advance and we'll work to do that. I apologize. I just was thanking them for making it possible for him to be here. I hope they didn't take that as I was dismissing them.
No, I think they misunderstood, Your Honor, is all.
Okay.
Yeah, that's what I thought.
All right. So we'll accept the not guilty plea on behalf of Mr. Quentin Ford Willis. And Mr. Castaneda, you and Mr. Brooks or Ms. Bing will be in touch, I'm sure. And then we'll reconvene as necessary.
Okay, then. All right. Thank you.
Thank you. All right. So if you don't have anything else, you're free to go.
All right, I have nothing else.
All right. Tell the other Johnnies I said hi.
I will. Bye-bye.
All right. Take care. Lasagna McConnell.
Yes, Your Honor, she's present on the Zoom call. I would need to conference with her.
All right. Elias Gabriel Rivera. Elias, this is Mr. Wood's case. Oh, Wheeler's back. So Mr. Willis, can y'all hear me?
Yes, ma'am.
Okay, so Mr. Willis, Mr. Castaneda just left. And what happened was he went into a breakout room to talk with the state. They're going to exchange information on your behalf. So for today, they entered a not guilty plea on your behalf so that they could continue to work out what was going on. And he said he would be in touch with you.
Okay. Thank you.
All right. So that is all I have right now. But we will in advance, once we know when you're coming back on the calendar, we'll make those arrangements to get you back here. And Mr. Castaneda said that he would be in touch with you prior to that.
All right. Thank you, Your Honor.
All right. Take care, sir.
Thank you. You too.
All right. So has anybody heard anything from Mr. Wood about Mr. Elias Gabriel Rivera? So if they're individuals working on behalf of Wheeler, yeah, we're done for today. Thank you all for making this happen for me. All right. All right. So let's figure out where Mr. Wood is and Mr. Rivera. Otherwise, I can issue a bench warrant bond forfeiture pending his arrival. All right. Kareem Assad Rogers. This is a closed case. Is this a petition? I just have that it's on the arraignment calendar, but it's closed. This is another one for PTI status. Do you have anything on this one, Mr. Brooks, from the pretrial?
For Rogers? Okay. I'm looking at the calendar. It looks like he pled to following too closely.
Yeah, I have that it was a plea, so I don't know why it's back on the calendar. Maybe he considered PT. Here it was. He was considering a plea in absentia. I think he actually came in and pled instead of doing the plea in absentia.
Gotcha.
So that case is closed. All right. William Moses Taylor.
Your Honor,
Yes.
I did make contact with Mr. Taylor last night. He did inform me that he was in the hospital. I spoke to the nurse and she did email me a document showing that he was currently in the hospital receiving care. I did forward that to Ms. Bing and yourself, just a document that was sent to me. That was from a Miss Alabi, I believe. And so he really couldn't speak too much when I was speaking to him. So I would have just tried to get a waiver from him, but we really couldn't have much of a conversation. Right. Let me see if I can find. There's Michael Alabi was the name on the email that I forwarded to you guys from Wellstar. There's a document from Wellstar Health System.
Yeah. And Mr. Lynch, you said he's a patient at Wellstar?
He's in the hospital for emergency care. He's not like it's for like a normal kind of health issue, not a
okay.
Okay. I just see the letter. All right. So I guess we'll reset this one for another date. And I don't believe you have any indication of when this might be.
I don't think it's going to be a very extended stay based on my conversation. Sounded like he was going to be in there for at least another week or so. But I don't think it's like going to be a long-term kind of thing.
Okay. All right,
And I have good contact for me.
this for me. Let me send it to you.
You want me to just?
No, I want, not that, this is what I'm sending you. I want you to hold on to that too, because both of them, I'm comparing. You see what I'm saying? You see that and this? Okay, I just want both of them printed out. All right, thank you. All right, so we will reset Mr. Taylor. I'm not sure how long we need to, maybe is it a month, 2 months?
I think a month should be fine, because what I'll do is get in touch with him, see if he's out, and but so I think a month should be fine. And if I can do that, I can potentially waive arraignment. But yeah, I think a month should be enough time in either case.
Okay, remind him that he doesn't need to be back here on the same thing he was here before. Genesis Roan Wilkins, Mr. Ibikwe.
Good morning, Your Honor.
Good morning, sir.
My client is Albert Judge. I think this case, Mr. Brooks, how are you?
Doing well. How are you doing, sir?
Good. We're still on the same program with this case, right?
That's my understanding. It looks like your client is paid and in the program is expected to be finished November 12th, 2025.
All right, so thank you, Mr. Ibikwe.
Thank you, Your Honor.
All right, y'all take care.
You too, Judge.
Your Honor, if the court would allow, I didn't hear the announcement on McConnell and Rivera.
Okay, I'll go back. So on Rivera, I had a bench warrant bond forfeiture, but pending figuring out, usually Mr. Wood, if he's sitting somewhere, he'll, make sure he sends us a leave. So you see, okay, a leave. So let me know. I'm just wanting to know if anybody has seen that he has issued a leave or if he didn't get a notice or something.
Yes, ma'am.
But otherwise, I'm issuing a bench warrant bond forfeiture for Rivera. And on McConnell, it's a conference.
Okay, conference. Okay.
Ms. McConnell is here.
Okay. All right.
All right. And the last case, Mr. Willis has entered a plea of not guilty, and Mr. Castaneda will be following up with him about that. Now, the jail calendar.
Oh,
Anthony, yes?
Before you move forward, I apologize for the interruption. I have here in the courtroom, there's Mr. Edward Hardnett. Mr. Edward, you can come up here, please. He is a pro se. He's here on a traffic case. He had the impression that he was supposed to be in court today, but he's supposed to be in court tomorrow on October 22nd. And he was hoping that Your Honor would be able to listen to his case today.
No. What's tomorrow's calendar, Ms. Val?
Right, for bench trials.
Yeah, no, because Miss Tortorello, bench trials, which means that people have been subpoenaed to be here tomorrow. So no, I can't listen to it today.
He's here to have him talk here.
Come on up, sir.
Good morning.
Sir,
Yes.
if you're on tomorrow's calendar, I cannot listen to it today. The reason is it's bench trials. And so that means people have been subpoenaed to be here tomorrow. And because they've been subpoenaed to be here tomorrow, I cannot listen to one side without giving the other side the opportunity to be heard, and they are prepared for tomorrow.
Okay, this is over a year old.
All of our cases are over a year old, sir.
I didn't know that, but anyway, the reason why I contesting this is because.
Sir, listen to me. I get all of that. And tomorrow I will be all ears listening to all of that. But what I'm telling you is, just like you deserve the right to be heard, so does the state. That's the law. And so because everybody is noticed to be here tomorrow, I cannot hear anything you tell me about your case today.
I have a real problem. And got to be at a doctor office, and I can show it to you tomorrow. They're gonna look at my kidneys.
Okay, well then that is just, you just want a continuance for a medical reason. That's fine. I can do that all day, every day. And in fact, telling me today helps this other side because that way they can release their officers. But I cannot hear it today.
Okay, but
So you have a doctor's appointment for tomorrow that will keep you from being here?
yeah, at 11 o'clock tomorrow.
I'm sorry?
At 11 o'clock tomorrow.
Okay, that's fine. What is your first and last name for me?
My first name is Edward, last name is Hartnett.
Hardnett?
That's correct.
All right. So, Mr. Hardnett, I'm going to allow you to have a continuance. We will notice you, meaning you will get another notice in the mail when we put this case back on the trial calendar. Be prepared at that time to bring, if you want to have an attorney with you, that's fine. If you want to bring any documents, pictures, witnesses, anything that you want to have for trial, even though you are not required to have anything or to present anything, if you want to. You want to have it on that day that we notice you for trial, okay? And I'm going to allow the state, Mr. Brooks, to release his witnesses that were supposed to be here tomorrow because you're not going to be here.
Right. Okay.
All right?
I'm fine.
Okay, thank you.
Thank you very much.
All right, take care, sir.
You all have a blessed day.
You too. All right, so Ms. Powell, Ms. Val, if y'all will just go ahead and continue Mr. Hardnett from tomorrow's calendar. And then Mr. Brooks, you all can let your officers know for that particular case that they are not required.
Thank you.
Yes, ma'am. All right, so back to the traffic calendar. I mean, back to the jail calendar. Go ahead, Mr. Lynch, you had something?
Oh, no, I was just getting ready for you to call the calendar.
Okay, so we started with Mr. Brooks. Mr. Brooks has a petition pending before me today. They also has a new case. The state has indicated on his new case that they wish to transfer the new case based on a previous battery conviction.
That's correct, Your Honor.
All right.
The previous battery was battery family violence was January 23rd, 2025, and he pled on September 16th, 2025.
Yes. All right. So if y'all present the transfer order, then I'll go ahead and transfer the case.
Yes, ma'am.
Marcus Davis.
Your Honor, I do represent Mr. Davis. That is going to be a negotiated plea today.
All right. Next is D'Angelo Michael Durden.
Judge, that's going to be the same announcement. We do have a negotiated plea in that case.
All right. Leroy Frost.
Did y'all ever find him? Judge, Mr. Frost, we're not appointed, but I'm sure he would like us to be. However, I think he might have been brought to the wrong courtroom. Deputies still trying to locate Mr. Frost, or either that he's just not up yet. So I will talk to him as soon as he gets here and follow up on that, Judge.
Okay. Brandy Harris, 2 cases.
Judge, we haven't spoken to the females yet.
Okay, no problem.
For that.
Jean-Baptiste, Jayla Jean-Baptiste.
And Judge, I think we'll still need to conference with her if you're going to appoint us.
Okay. And then another female, Shantavia Lawrence.
Correct.
Kenneth Say Mahone.
Did you talk to him? Judge, we'll need to conference with Mr. Mahone further. I'm sorry.
Diedrich Randolph Martin.
Judge, I have spoken to Mr. Martin. I previously was in the process of trying to get the bench warrant lifted. I did submit some documents showing that he was actually in a rehab or inpatient facility from before the date of the arraignment was not released until after. I was hoping the state was going to consent to that. Ms. Bing and myself had some conversations about that, and then I did forward the email with those documents to Ms. Bing and yourself a couple times last week. I was just hoping that the state would consent to lift the bench warrant for those reasons, or Your Honor would entertain that.
Okay, he's in a rehab facility or a
No,
medical?
he's not in a rehab facility now. He's in the Clayton County Jail, but on the date of his arraignment, he was in a rehab facility. And the documents that I presented, I believe, show that he went in on May 5th and came out in sometime in June. The arraignment, I believe, was May 21st.
Well, it seems like the bench warrant has been executed. If he's in.
Yeah, so whatever he does today will kill the bench warrant. You want him to be released, is what you're saying.
Correct, Judge. He does indicate that he wants to contest his case. He does have, well, we won't get into the facts, but.
All right, so what you want to issue a not guilty?
Yes, Judge, but I would ask the court to release him, since the only reason he's in custody is because a bench warrant was executed at a time when he could not be present in court due to him. And especially, he was seeking.
Okay. Just make sure he comes out so I can remind him that he's not to be here on the same stuff again.
Absolutely, Judge. Could we go ahead and bring him out right now? If
Yeah.
or want to go through the, will you bring out Mr. Martin?
Yeah, draw it up and I'll sign it.
This is his arraignment, correct? He's being arraigned and he's pleading not guilty.
Correct.
Right. And been arrested on the bench warrant, so okay.
Correct.
Yeah, so I can release the bench warrant. He's having his arraignment.
Thank you, Your Honor. Stand right next to me, Mr. Martin. Oh, sorry.
So, Mr. Martin, your attorney has presented information that at the time that we had arraignment prior to this, you were in a program and you weren't able to make it. So the bench warrant was executed, but we're going to, based on those representations, we're going to let you out. But please make sure that you keep in touch with your attorney. Please make sure that you are not back here on the same type of charges. Are you listening to me?
Yes, ma'am. I'm so grateful. That's what I was trying to tell him.
No, that's okay. I know that's fine, but I want to be grateful that we just dealing with this and nothing else comes after this. You got me?
Yes, ma'am. Totally, y'all.
All right. All right. Thank you, sir. Mr. Lynch is going to give me the paperwork.
And Judge, so I did submit a bench warrant recall on that. Do I just need like a separate order, or would that?
No, I mean, did I sign it?
You didn't, Judge, and I think, well, you just didn't sign it, but I
submit it.
I can resend that email to you.
Yeah, I don't even remember seeing that. And I was at the conference, so if it happened last week, we had horrible Wi-Fi, horrible radio signal.
I understand that.
I'm looking for it. Yeah, just resend it. I'll sign it.
Thank you, Judge.
I just finished signing everything that I was outstanding yesterday because of that. All right, next is Portia Martin. I guess y'all haven't spoken to any of the females, so we'll wait on that.
So, Judge, I actually did speak to Ms. Martin, and I believe that is going to be a negotiated plea. I do just want to ask the state about basically the obstructions charge due to her circumstances, but she's the one female I was able to talk to so far.
Okay, then I have O'Garis. I believe that's O'Garis McGee.
Yes, Judge. Mr. McGee is going to be a negotiated plea today.
Okay. Thomas McGrath, 2 cases.
Judge, we're going to enter a not guilty plea for Mr. McGrath today. And,
for both?
Yes, okay. Judge. I'm going to have to, I'm going to enter a not guilty plea for today.
That's fine. Miss McKnight was, so my understanding was we gave you more time for Miss McKnight because she had a hearing that was taking place upstairs. Are we in a position right now to complete her case and her petition?
I think we are, Judge. If I could just speak to her briefly about that to get on the same page, but I think we should be.
Okay, cool. And last but not least, the last two cases, Emmanuel Monfiston.
Yes, Your Honor, I would need to conference with the state on that one.
All right, and Stansel, Emily Lynn Stansel.
We would need to conference with her, Your Honor.
All right, so I'm gonna give y'all some time to conference. Use it well, and then when we come back, we're going to roll. Yes, Mr. Lynch.
Well, certainly not. We will do as you instruct, Your Honor. I was just going to suggest if you wanted to go ahead and take a couple of the pleas while.
Yeah, that's fine. I can do that, and that'll clear the back.
And Ms. Bing, do you think you can send me the accusation and police report for LaSonia McConnell so I can discuss her case?
Yes, I can do that.
Thank you so much. And Your Honor, if you could place me and Miss LaSonia in a breakout room.
Okay.
Judge, if we could go ahead and do Mr. Marcus Davis.
Okay.
Are you done with Ms. Martin?
Yes, for right now.
I'm gonna just switch them on.
So I found the attachments from May 21st, but I can't find all of them. There's so many. Stand right next to me.
Mr. Davis? It is?
Yes, this is Mr. Davis. Or yeah, his last name is Marcus. Marcus. Yeah, sorry. Yes.
Okay. All right. Thank you.
All right, this is Mr. Davis.
Yes, Judge.
All right, Mr. Davis, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So, Mr. Davis, you're before the court on State of Georgia versus Marcus Davis, 2025 CR 09452, for driving on a suspended or revoked license, no license, stop or yield sign violation. You're represented by Attorney Owen Lynch with the law firm of Lister, Holt, and Dennis. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, it's going to be a no contest plea to count 1 and a no contest plea to count 3. I believe count 2 would either merge or be no pros. I guess technically it's a no pros.
All right. By entering a plea of nolo to counts 1 and 3, count 2 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, present evidence and testimony on your behalf, to not incriminate yourself or present testimony and evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir? All right, factual basis and recommendation, please.
Yes, on September 28, 2025, officers observed the defendant driving on Newdale Road, Newdale and Oakley Drive in Rex, Georgia. When they made contact with him, I believe they had seen him roll through a stop sign. When they made contact with him and they ran his information, they found that his license had been suspended on September 22nd of 2022. His recommendation is for count 1, 12 months to serve 23 days, credit for time served, $500 fine, suspended, and the balance can the balance can suspend. Count 2 is no pros. Count 3 is just a $100 suspended fine.
All right. So, Mr. Davis, why was your license suspended, sir?
I believe it was a failure to appear.
Let me tell you how to have that never happen again. If you ever get pulled over, take a picture of the ticket, because we always lose the ticket. Put a reminder in your phone. We have these supercomputers that we never used for the proper thing. Put a reminder in your phone of the date and location of where you need to go for the court date, and put a reminder some days before that so you can remember to take off time from work, get your kids squared away, whatever it is you need to do to make sure that you're there on time. That is how to never get another failure to appear. Do you understand? You got me?
Yes.
Take a picture of the ticket, put a reminder in your phone. You got me?
Yes.
All right. So I'm going to accept your plea. No load to counts 1 and 3. Count 2 will be no pros. 12 months, 23 days, credit for time served, balance suspended, $500 fine suspended. Count 3 will warrant concurrent, $100 fine suspended. Okay? Don't ever spend this much time in jail for something that's that simple. Okay? And get your license.
Will do.
All right. Take care.
Do Durden next. If we can do Durden next.
Okay. All right, Mr. Durden. Raise your right hand for me. You solemnly swear or affirm any testimony given this matter will be true. Do you understand?
Yes, Your Honor.
Okay, thank you. You can put your hand down. So Mr. Lynch, who is your attorney, is representing you on case 2025 CR 09583. Mr. Lynch, your client is before the court for theft by shoplifting. What does he plead to the offense before the court?
Judge, he's going to enter a plea of guilty today.
All right, by entering a plea of guilty, Mr. Durden, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, I do.
All right, factual basis for recommendation, please.
Yes, on Monday, September 22nd, 2025, officers were dispatched to the Quick Trip at 5185 Highway 85 in Forest Park, Georgia, in reference to a disturbance at that location. The caller was an employee from Quick Trip, and he had told, or she had told, the 911 call taker that the defendant had stolen merchandise from the store and provided a description of that person. When officers arrived, they observed a man matching that description outside of the Quick Trip. When officers made contact and asked him why he was stealing, he claimed that the Quick Trip always lets him have free food. Officers asked the man if he had asked the Quick Trip clerk if he could have the items or if he just took them. And the defendant stated that he just took them and also added that he did not pay for those items. State's recommendation is 12 months to serve 29 days, credit for time served, balance suspended.
All right, Mr. Durden, I'm going to accept your plea of guilty. I'll sentence you to 12 months to serve 29 days, credit for time served, balance will be suspended as long as you do not go back to the Quick Trip and you have no new violations of the state of Georgia.
Yes, ma'am. Thank you. Yes, ma'am. Thank you.
All right, thank you.
You done?
Yes, sir. Yes, you should be released. If we could get Mr. McGee. Yes, sir.
Excuse me, Judge.
Yes.
I am here for Larry Frost. I don't think I ever heard you call his name.
I did.
Maybe I missed it. I just want to make sure I'm not hanging out if it's not on your list.
You're here as a witness?
No, we're the property manager.
Okay, yeah, I did call Mr. Frost. They were trying to bring him up from
That's fine.
downstairs.
I just wanted to make sure I wasn't here if he wasn't.
Yeah,
actually.
no, they were waiting to bring him up.
Okay, perfect. Thank you.
You're welcome. Who's this, Mr. Lynch?
I'm sorry, Your Honor. This is Mr. McGee. He's here for a plea.
Okay, I thought,
McGrath was the not guilty.
okay. This is Mr. O'Garis McGee.
Yeah, I may have said that backwards, Judge. I'm sorry.
No, I think I was thinking it differently. All right, so Mr. This is case 2025 CR 09383. Mr. O'Garis McGee. Mr. McGee, please raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. You're before the court on state of Georgia versus O'Garis McGee for battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4. Mr. Lynch, what is your client plead to the offenses before the court?
Judge, he's going to plead guilty to count 1, and I believe the remaining counts would merge.
All right. By entering a plea of guilty to count one, counts 2, 3, and 4 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right. Factual basis recommendation, please.
September 24th, 2025, officers responded to 5790 Highway 85, apartment 607 in reference to a domestic disturbance. Officers spoke to Mr. Olan McGee, who I believe is the father of the defendant, Ogarius McGee. Mr. Olan McGee said that his son is in and out of his home, and every time he allows him to visit and take a shower and clean up, he causes problems, and that day was no exception. He began being disrespectful, and so the father had asked him to leave, and at that point, the defendant started to swing on him. That's a quote, and hitting him in his face, causing him to have a busted upper lip. To note, the father had recently had surgery and was very immobile when this occurred. The state's recommendation is, 12 months to serve, 21 days, balance probated, an anger management course, a moral recognition course, and a 300 MRT. That's moral recognition. I don't remember what the T is for.
Okay, this is a new one on me, and I'm not even going to be ashamed about saying that. Moral recognition. What is that?
Yeah, in Judge Spencer's courtroom, sometimes that's recommended so that you can kind of get to the root of like why this is a wrong course of action, and considering
Who teaches that course?
I don't know personally, but it was recommended in response to the fact that he became violent with his father, who was in a very fragile state, and so just and that it's chronic. So it's recommending both of those courses, a suspended fine of $300 and no contact with the victim. And of course, his father is welcome to come back to court and change, whether or not he wants to have no violent or harassing contact. But until that happens, we'd like to place a no contact order in.
Okay, let's talk. Mr. Lynch, is your client in a position to be able to do these things?
I believe he can complete the courses that are suggested.
Okay, and I've never done a moral recognition course before, but hey, let's try it. So 12 months to serve 21 days, credit for time served, balance will be probated for you to take an anger management course and a moral recognition course, and a suspended fine of $300 and no contact with Mr. Olan McGee. All right. All right, Mr. McGee, you can go back with the sheriff's office.
And Judge, I think at this point, I'm going to go see where we are with some of the females, and hopefully we can clear everything else up.
Are we on Ms. Jane's case?
What case is that?
Isn't it Brown, the first inmate? Brooks. Anthony Brooks.
Yeah, we haven't done Brooks yet.
Okay.
I thought, and I want to confirm this with Ms. Tortorello, but I thought that the announcement may have been that he was requesting an evidentiary hearing, but let me confirm that before you mark that on the calendar. Your Honor, I'm going to see if we can do Ms. McKnight real quick.
Yes.
I do have Shakia McKnight. She is ready to go forward with the stipulation to the VOP and the plea on the underlying misdemeanor case. If you're willing to take that. She is still held on the felony case. She didn't get any kind of resolution at the arraignment, but she's got another arraignment coming up. I have been trying to get in touch with the attorney, but I haven't spoken to her public defender about possible mental health court. But that's
Nicole, what's her name?
Jones, I believe.
Yeah, she was in trial last week.
Right. That might have been the issue.
Yeah, she had a trial.
My plan was to reach out to someone else I knew there so I could get a direct number, but I haven't got that direct number yet.
Yeah. Okay. All right, bring Miss McKnight out.
Yeah, McKnight, she's sitting there. September 30th. You're gonna stand right next to me, Miss Arnold. I mean, Miss McKnight.
Hey.
I got probation for, I'm on probation with DCAT.
Miss McKnight.
Your Honor.
All right. You're before the court on a petition for revocation of probation
Yes, ma'am.
and an additional case. So pull up the petition first.
Yes, ma'am.
How you feeling?
Oh, I'm tired. Just ready to get this stuff over with, Your Honor. So I can get home with them babies. Tired.
I got you.
Tired.
All right. So this is State of Georgia versus Shakia Renee McKnight, 2025 CR 03522 for petition for revocation of probation. Ms. McKnight, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am. I do, Your Honor.
Okay, you can put your hands down. You were before the court on simple assault on the 19th day of August, 2025. You were sentenced to 12 months. You had 11 months and 3 days remaining. And it says that you were arrested for the new offense of giving a false name, address, date of birth, public drunk, loitering or prowling, and obstruction on or about August 20th, 2025. All right. And Mr. Lynch is representing you. Mr. Lynch, what say you on the petition? Ms. McKnight, you are also before the court for 2025 CR 08814 for giving false name, address, or date of birth, count 1, loitering or prowling, count 2, obstruction of an officer, count 3, giving false name, address, or date of birth, count 4, and public drunk, count 5. All right, so Mr. Lynch, petition or new case first, whichever you wish.
We can do the petition first, if that's expedient. She is going to stipulate that violate her probation in the way alleged. And I believe we're going to we're going to ask the court to accept the recommendation from Mr. Austin.
All right, Mr. Austin, what's your recommendation in this case?
Your Honor, the recommendation is 90 days to serve and close this case out.
All right. Mr. Lynch?
Judge, I would ask that you accept that. I think Your Honor is aware of some of the issues Ms. McKnight is dealing with, so I'm not going to necessarily give you a whole sob story here, but I do think that she is ready to try to address some of these issues as she tries to resolve her pending matters before Clayton County.
All right, Mr. Austin, I'll send it over. It reads, defendant shall serve 90 days with credit since the date of lockup. This case will also run concurrent with the sentence in case 2025 CR 08814. After service of the 90 days as ordered by the court, this case shall be suspended and the defendant shall be released.
Thank you, Your Honor.
All right. All right. So with the giving false name, address, or date of birth, this case, what does your client plead to the offenses on case 2025 CR 08814?
Judge, those are going to be guilty pleas.
On all of them?
Yes, Judge. I'm sorry.
All right.
Pull it up.
By entering a plea of guilty to counts 1, 2, 3, 4, and 5, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am, I do, Your Honor.
Factual basis and recommendation, please.
Yes, ma'am. On August 20th, 2025, officers with the Clayton County Police Department were doing a patrol in the area of Sector 4, Forest Park of Clayton County. Officers observed two females appear to be in altercation. Officers made contact. One of the females was identified as Miss McKnight. During the course of the encounter, officers did make observations of impairment on Miss McKnight, to include red, glossy eyes and incoherent statements, etc. Officers inquired of her identity, and she provided a false name of Brittany Thompson and a false date of birth of January 24th, 1992. Officers ultimately placed her in arrest for giving false name, loitering, prowling, obstructing, giving false date of birth, and public drunk. This all occurred here in Clayton County. State's recommendation is 12 months to serve, 90 days to run concurrent with her probation revocation. Balance is to be suspended.
Thank you, Mr. Brooks. That saved me some breath.
All right, so counts 1, 2, 3, 4, and 5 will run concurrent with the same sentence. 12 months to serve 90 days. Credit since the date of lockup, balance suspended. This case will run concurrent with the revocation in case 2025 CR 03522.
Thank you, Your Honor.
All right, Miss McKnight, baby, you know when you're pregnant, you're not supposed to drink, okay?
Oh, yeah, I know that one.
All right, go take care of yourself, okay?
All right, listen.
All right, you guys need the time? So this is what I have left. Let's just be clear. On the arraignment calendar, so Mr. Campbell is a bench warrant bond forfeiture, but that's pending. He had a pending eval order, so we're not sure what's going on with him. He was here for a status check. Mr. Downer was a plea. Mr. Lewis is a null pros. Miss Marklin, Holness, that was a PTI. So we'll revisit that after the November 12th updates. Nancy Maya is PTI. McConnell is a conference. Rivera is a bench warrant bond forfeiture. Rogers is closed. Taylor, William Moses Taylor, is reset for medical reasons. Wilkins is PTI, and that'll be verified as of the November 12th status. Willis is a not guilty. On the jail calendar, Brooks, we're still waiting on the petition for Brooks. The second case for Brooks will be transferred. The new arraignment, Marcus Davis, that's a plea. Durden is a plea. We haven't got Mr. Frost up yet, so we don't have an announcement on Frost. Harris, Ms. Harris has 2 cases. We do not have an announcement on Jean-Baptiste, which is a petition, and Shatavia Lawrence. We do not have an announcement on Mahone. We have a not guilty for Martin, Dedrick Martin. We have a plea for Portia Martin, which we need to take. We have a plea we took for O'Garris McGee. McGrath, Thomas McGrath is a not guilty on both cases. Shakia McKnight, we've completed the petition and the plea on the second case, and we're waiting on an announcement for Monfiston and Stansel.
Yes, Judge. And what I want to do right now, maybe to speed this along, is if I can chat either Mr. Brooks or Miss Bing, whoever's going to be handling Miss Martin, I just want to ask for one potential modification to the recommendation, and we should be able to go forward with that plea.
Okay.
Miss Bing.
All right. So Miss Bing, I'm gonna put you in breakout room number 2.
That's fine.
Put Mr. Lynch in breakout. Mr. Lynch, are you gonna be coming from Ms. Tortorello's computer, or you want the whole courtroom?
I'll just do it right here. The courtroom's empty, and
okay, that's fine. All right. There you go. Okay.
And I'll talk to
And-
Mr. Frost next, because Mr. Frost is up here now.
Okay, so the lady who's waiting, I'm sorry, I did not get your name, but Mr. Frost, they're gonna speak with him, and as soon as we can get, announcements on the rest of the people, we'll start bringing them up, bringing them
Okay.
forward. Okay,
Thank
thank
you.
you. All right. I'll be back.
Hey, Ms. Bing, so Ms. Tortorella is trying to get a accusation and police report from Ms. McConnell. If you look,
Lauren was supposed to have sent that a long time ago.
yeah, so Lauren, in her initial email for today, indicated that that accusation was previously sent for the May 21st arraignment, which is true. We're not contesting that, although I'm looking through all my emails and I cannot find it. So what I'm hoping is we can.
I thought she was going to walk it down.
Oh, well, I don't, if that's the case, we haven't seen her.
Okay.
But that, just putting that out there. And this is Miss Portia Martin.
For McConnell, right?
Yes.
All right, I sent her another message.
Thank you.
Okay, so she says she just resent it.
Thank you.
All right.
And Ms. Bing, I'm gonna have to break out with you and for some of my cases, so.
Okay, well, let me know which one I know you said Monfiston, but I don't have that file. I think that might be Mr. Brooks. If you're talking, I can't hear you.
Sorry. Harris, I need to speak to you about Brandy
I have
Harris
that.
and Stansel.
Harris, Stamsel, and what was the other one?
Monfiston.
Yeah, so that one I think Mr. Brooks has, but I have the other two.
All right, so I don't know, do I just speak to Mr. Brooks then about that one?
Yeah, do you want to, while Mr. Lynch and I are handling this, do you want to break out with Mr. Brooks?
I'm already in the breakout room with Ms. McConnell. I mean, I can get out here. Mr. Brooks, can I just call you?
Yes.
Okay, thank you.
Mr. Lynch, are y'all ready? Or are you conferencing?
No, Judge, we're ready.
Okay, well, somebody needs to tell me.
Sorry, Judge, I thought you, all right, hold on, judges on the bench. Judges on the bench, right, okay. Your Honor, we're ready to go forward with the plea for Ms. Martin.
Well, it's non-negotiated, I think, at this point. We had agreed to just give her time served, and I think we both were fine with that. My only caveat was a potential mental health evaluation based on her prior convictions that suggests that there may be some mental health issues here. I would like to just to defer to the court. There's been
Ms. Bing?
yes.
All right.
No, I'm not trying to interrupt you. I just wanted to say, we could do the plea and then talk about sentencing afterwards.
Yeah.
Right?
All right. So
Sorry.
this is, who's this on my calendar?
This is Portia Martin.
Okay, Ms. Martin. Raise your right hand for me, ma'am.
Hold on. Listen to the judge.
Okay, Judge.
Can you see me, ma'am? That helps sometimes if you can look at me.
Now I see you.
See me talking. All right, Ms. Martin, good morning.
Good morning.
Raise your right hand for me. Do you solemnly swear or affirm any testimony you give will be true?
Yes.
Okay, you can put your hand down. You're before the court on State of Georgia versus Portia Martin, 2025 CR 09584 for criminal trespass count 1, obstruction of an officer count 2, and public indecency count 3. You're represented by Mr. Lynch. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, she's going to enter.
I'm pleading guilty. Second charge, I'm pleading not guilty. Third charge, I'm pleading guilty.
Hold on one second.
Mr. Lynch, you good?
Can I just have one moment, Your Honor?
Okay, I just.
Sure, no problem. Miss Martin, hold on. Let him talk to you off the mic, okay?
Your Honor, we're ready to go forward. There's a slight miscommunication on count 2.
No problem. All right, so Ms. Martin is pleading what to the offenses before the court?
Guilty, Judge.
To all of them?
Correct.
Yeah. So by entering a plea of guilty to counts 1, 2, and 3, Ms. Martin, you give up the right to have a trial by jury or judge. You give up the right to have the state prove you guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. Excuse me. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
I'll say yes.
Okay, thank you. Factual basis and recommendation, please.
On September 28, 2025, officers observed the defendant roaming the hallways of the airport after hours. When officers asked her if she had a boarding pass or an airport badge on her, she stated no. They advised that the airport was currently closed to the public unless traveling or working at the airport. At that point, she took flight toward the parking deck. Then when officers gave chase, she stopped in the middle of the parking deck, pulled down her pants, and began to urinate in public on the parking deck. The state is recommending for count 1, criminal trespass, 22 days to serve. Do not return, balance suspended. And we're going to defer to the court about a mental health evaluation. Count 2 is obstruction, is a $300 fine, suspended. And public indecency, 12 months to, 12 months to serve 22 days to run concurrently with count 1.
All right, so let me just clear this up. Ms. Martin is not new to me. She has had mental health evaluations previously. I don't know that her status has changed such that appreciably from the last time that she was evaluated. So I'm comfortable if she appears to understand the process and to be able to speak with her knowledgeably with her attorney. Mr. Lynch, do you have any concerns other than what I've stated?
Judge, I do not. I think there are issues that Ms. Martin is dealing with, but I do believe she's competent. She understands what she's charged with. She understands the court process. She also, I do think that Ms. Bing was suggesting more. I think her suggestion was in terms of like not a competency evaluation, but maybe like a mental health evaluation in terms of diagnosis. But I don't think that that is an issue here. And I think the problem for Ms. Martin is going to be she doesn't really have resources. Now, I wasn't aware that you had a lot of experience with Martin, Ms.
Yes,
Martin.
ma'am. Yes, sir. I've met Ms. Martin a few times.
Okay. From speaking to Ms. Martin, she does intend to leave our jurisdiction, but I'm not sure.
Well, I will say this. It's been a while since I've had an encounter with Ms. Martin, so there may be resources that we're not we're not aware of that are available to her. Yeah, she's been before the court before, and we can verify that if we need to. But I don't forget a whole lot. Ms. Martin is saying not me, but I'm pretty sure if Ms. Wright looked it up, she's been here before. I am comfortable with her ability to navigate at least this part of the legal system. I'm not sure that an evaluation to name a condition would help us in this situation, especially if it is not tied to her getting any particular services.
Thank you.
Okay. All right. So I'm going to accept your plea of guilty to counts 1, 2, and 3, Ms. Martin. I'll sentence you to 12 months to serve 22 days credit for time served. Balance will be suspended on count 1. Count 2, 12 months, 22 days credit for time served, and fine of $300 will be suspended for credit for time served, and that will run concurrent with count 1. Count 3 is 12 months, 22 days, balance suspended to run concurrent with count 1.
Thank you, Your Honor.
All right, thank you.
You can go back. You can get released.
It was easy, Mr. Lynch.
Has everybody been talked to? Okay, so it sounds like she did talk to him also. And then I guess if we got Frost, put Frost in there.
Okay, I'll put false books and we got needs to see motion. Falls, Lewis, and McGee. We already did the beyond you. He needs to see probation. Oh, right. She'll come back. She came down here all 2 months.
Yes. Wait, let me mute.
Is Mr. Frost here?
Okay,
Can you put Brooks back in there? Be back in there? All right, good.
Brooks, Frost, and McGee.
So, so we can get Miss Lawrence up, please. Yes, she's a female.
send it to the attorney. The judges can be on this.
Good afternoon.
Miss Tortorella, did you want to talk?
I already resolved most of my cases with Solicitor Brooks.
Okay, but we have the two together, right? Frost and Harris?
Frost, I believe, is
I got it. Nothing on Frost.
Harris is yeah, I need to talk to Harris with you. Frost, I believe, is
So it's a negotiated plea, but we are happy to agree to a reasonable amount of restitution rather than putting it down for a hearing if the state can do that.
Sorry, I heard some of what you said, Mr. Lynch. You said negotiated plea, happy to something.
So sorry to interrupt, just
Yeah.
briefly.
Not at all.
It says restitution to be determined. However, I see the victim is on, and we would likely agree to a reasonable amount of restitution that would compensate her rather than have to, kick it down the road.
What that look like? Randy Harris, right?
For Frost.
and this is Shantavia Lawrence, and she's ready for to move forward with a negotiated plea.
Ms. Tortorella, we ready?
Yes, Your Honor.
Okay, who's this for me?
This is Ms. Shantavia Lawrence.
Ms. Lawrence, step up a little bit for me. I'm having trouble hearing today. My sinuses are acting up and my ears aren't working. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
Okay, you can put your hand down. So, Ms. Lawrence, you're before the court on 2025 CR 08810, Shantavia J. Lawrence, for criminal trespass. You're represented by Attorney MJ Tortorello. Ms. Tortorello, what is your client plea to the offense before the court?
That will be a NOLO, Your Honor.
All right. So, Ms. Lawrence, by entering a plea of NOLO, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Can negatively affect my immigration status?
Okay, so I say that to everybody because I do not ask people whether or not they are a citizen of this country. If you are a citizen, it may not affect you, but I say it to everyone, okay?
Yes, understood.
All right. Thank you. All right, factual basis and recommendation, please.
Okay. Sorry, give me 1 second.
And defense stipulates to the facts.
Oh, if you're fine with the stipulation, I'm fine with it. State.
Yes, I'm
Okay.
fine with that.
Recommendation.
Okay. The recommendation is 12 months to serve, 52 days, credit for time served, balance suspended, do not return. And that address is the Econo Lodge, located at 5060 Frontage, Frontage Road in Forest Park, Georgia, in Clayton County.
Frontage road.
Frontage?
Yeah.
Okay.
So generally, if you see a frontage road, it usually means that it's running parallel to an expressway or a highway.
Oh, okay. Gotcha.
So it'll be like right on the side of a highway, a separate little road running there. All right. So, Ms. Tortorello, anything on behalf of Ms. Lawrence?
Yes, Your Honor. I believe she has an active bench warrant against her. If that could be set aside, given that this case is
The appearance should set that aside
okay.
as long as it's for this case.
Okay.
All right. So once she enters a plea, the bench warrant has been satisfied. Ms. Lawrence, how old are you, ma'am?
How old am I?
Yes, ma'am.
I'm 23 years old.
Okay, so Miss Lawrence, in order to help you transition back out onto the street once you leave jail, you might want to talk to some of the chaplains because they may have information about maybe a shelter or a situation where you might get like bus fare if you need to. They have resources that I don't know about, but they usually compile resources. And if you ask to speak to a chaplain before you leave the jail, they may be able to give you that information. Okay. All right. Take care of yourself, Miss Lawrence. It's rough out there, all right?
Thank you so much.
All right. Take care, ma'am.
Thank you so much. Thank you guys so much. Have a great day.
You too. All right.
Can you bring out Jean Baptist? Jean Baptiste. This is a probation revocation matter, Your Honor, so I believe, probation.
Well,
Jean or Jean Baptiste.
oh, Jean Baptiste. Okay.
Oh, just about basically, you want me to talk basically that he can either.
Good morning, Ms. Chang.
Good morning, Your Honor.
All right, Ms. Jean Baptiste. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So this is State of Georgia versus Jayla Mona Jean Baptiste, 2021 CR 06029. Ms. Jean Baptiste, you were before this court for driving on a suspended or revoked license on the 7th day of November 2024, sentenced to 12 months on probation. Was this pay-only probation, Ms. Chang? Ms. Chang?
Yes, Your Honor.
Okay.
Pay only.
And 8 months and 10 days remaining. It says that you have never reported to probation and that you missed reports that were scheduled for November 13th, November 18th, December 4th, February 4th, and within 10 days of February 5th. And you are currently $540 in arrears, specifically $390 for the court fines and $150 for probation supervision fees. Ms. Tortorello?
Yes, Your Honor, we are stipulating to the violation and accepting probation's recommendation.
All right. So, Ms. Jean Baptiste, where were you? What happened? Because we gave you time to pay and then you didn't show up.
Do I look over here? Okay, you remember I was pregnant and then my baby father. I lost my baby and I lost my baby father.
Ms. Jean Baptiste, my condolences, ma'am. That is hard. That's hard.
I just been all over the place. I actually didn't really heal until I got here and really just was able to read my Bible and just get to know people and build my relationship with people in here. But
Ms. Jean Baptiste, let me tell you something. That's a hard blow. You have suffered a hard blow. Let me tell you some of the things that might help a little bit. There are grief support groups, and you were talking about reading your Bible. A lot of them are sponsored by churches, but not all of them. So I know of one. I used to see the sign when I passed it. There's a church on Jodico Road in Henry County, and they have a grief support group, and it's right if you come up around the little shopping center where the Old Navy and the Home Goods is. On the other side of that, as you go down the street, there's a church, and it used to have a grief support group there. And I know that if you,
what's
I'm sorry.
What's the name of the church?
I cannot remember. It's a little tan exterior of the church is tan, like a tannish brown. But this is what you do. Take your phone and just Google grief support near me. Okay? Because the thing that helps if anything helps, is to be able to share and talk with people who are supportive. Okay. Because you're not, people will tell you, well, you should be over this by now, or nobody can tell you when your grief ends or when it changes into a different phase. Okay. But to have people around you who are supportive of you and who have been through some of what you've been through, do that. Because just Google grief support near me, and grief support groups usually are voluntary. It's not going to cost you anything. You can meet as much as you want or as little as you want. Oh, look at Miss Hempfield. I love you. Thank you. Shiloh Baptist Church in McDonough also has it.
Okay, I'm
And
her
First Baptist Church in McDonough has a grief support group. Thank you, Miss Hemphill. You're amazing. So just like I said, those are two of them. But I believe if you just Google, grief support near me, then you can get to that and just get that support, because I don't want you to spiral out of control. I want you to be able to kind of have that support that you need, because this is hard. Okay. And I'm going to be praying for you. And trust me, there's no shame in feeling what you're feeling. Okay.
Judge, if I may.
Yes, ma'am.
Just south of us here on Terra Boulevard, south of the Kroger, there's a church on the right. Bonanza or Terra is a Baptist church that has a sign out by the road that says Grief Share. So they have a program there.
There you go. Right down from the jail as you're going down Terra Boulevard. Okay.
Okay. Thank
So
y'all.
there are a lot of programs around where people will sit and they will share with you, and they will hear your pain and they will share their pain, and y'all will get through it together. Okay.
Yeah.
All right. And I'm just glad you made it here today. I mean, I'm sorry we had to find you, but I'm glad
I've
to
been here
know
for
that you.
so I've been away from my babies, but they've been with his mother, so I've been okay. I just feel like
Okay.
I'm happy.
All right. Well, let's see if we can't get you out of here. Miss Chang, what's the recommendation in this case?
Your Honor, just 11 days to serve, credit for time served since October the 10th, and close the case.
All right. Sounds good to me.
Thank y'all so much.
All right. Miss Baptiste, just remember, there are other people going through this. You are not alone. And when you share with those other people and they share with you, y'all support each other. Okay.
Yes, ma'am.
All right. I'm going to be praying for you.
Thank you.
Okay. You're free to go. You're going back. Okay. All right. So 11 days credit for time served, case closed.
Yes, sir.
Oh, sure.
And
Mr. Lynch? Oh, sorry. I sent you a message on your phone about Frost restitution.
Can we hold off that for 1 second? Can we hold off on that? All right, just give me one moment. You want to call you next, please?
I would like Ms. Cancel. Yes, thanks.
All right. I'm ready whenever y'all are. Just let me know.
We're waiting on Ms. Stansel, Your Honor.
Ms. Stansel, raise your right hand for me. You
Ma'am.
solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, so Ms. Stansel, you can put your hand down. So you're before the court on State of Georgia versus Emily Lynn Stansel, 2025 CR 09384, theft by shoplifting and obstruction of an officer. You're represented by attorney MJ Tortorello. Ms. Tortorello, what does your client plead to the offenses before the court?
Your Honor, for count one, theft by shoplifting, that will be a guilty plea. And my understanding is the obstruction will be no prost.
All right. By entering a plea of guilty to count one, count two will be null pros, Ms. Stansel. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Yes, Your Honor.
All right. Factual basis recommendation, please.
Yes, ma'am. On September 21st, 2025, officers with the Forest Park Police Department responded to 4735 Jonesboro Road, Dollar General. Officers made contact with complainant employee from Dollar General, who advised they observed female taking items without and passing all points of sale without paying for the items. Officers were able to identify that female as Miss Emily Stansel. Officers did make contact with Miss Stansel, and within her belongings, she had $72.03 worth of merchandise that was unpaid for. This all occurred here in Clayton County. State's recommendation to count one is 12 months to serve 30 days. The balance is be suspended upon her not returning to 4735 Jonesboro Road, Dollar General.
All right. Ms. Tortorello?
Yes, Your Honor, only that you accept the plea as negotiated.
All right, Ms. Stansel, what we dealing with, ma'am?
What's your question, Your Honor?
What kind of addiction we dealing with, ma'am?
You can tell. Yes, ma'am, I am an addict. I will admit I'm an addict. I've been an addict with street drugs such as methamphetamine and like cocaine for about years now.
If you are given the opportunity, unfortunately, I don't have a rehab facility, but if you are given the opportunity to go into a rehab program, if somebody can support you in that, if you got family members who've been encouraging you to go, if they're pushing you to kind of get yourself together, if you go and talk to someone at the Salvation Army and they're able to say, hey, we got a program for you, we can get you in. Take whatever lifeline is thrown to you, okay?
Okay. Yes, ma'am. Yes, Your Honor.
You're fairly young and you don't want this to take your life,
Yes, ma'am.
okay? It has probably already taken a lot from you.
It has. Like I could try right now, just at that statement alone. You right? Yes, Your Honor.
So just if you are given the opportunity at any point, if somebody throws you a lifeline, you grab on because your life does depend on it, okay?
Yes, Your Honor. I promise to not take any opportunity given to me for granted.
And it's gonna be hard. Now, I'm not saying it won't be the hardest thing you have ever done, but hopefully you will have that opportunity and that you will have the opportunity to kind of get your life back, okay?
Yes, ma'am.
I'm gonna be praying for you. 12 months, 30 days, balance will be suspended as long as you do not go back to the Dollar General on Jonesboro Road and that you have no new violations of the laws of the state of Georgia, okay?
Thank you.
All right, take care of yourself, ma'am.
All right. We are ready on Harris. Ms. Harris.
To make sure we're all on the same page, I'm gonna go, we're still waiting on Brooks's petition. The other case is gonna be transferred. Davis is a plea, Durden is a plea. Frost, we still haven't heard from. We're about to do Harris's two cases. Jean-Baptiste was the stipulation. Lawrence was a plea. We're still waiting on Mahone. Martin is not guilty. Zedrick, Martin Portia is a plea. McGee plea, McGrath both not guilty. McKnight, stip and agree, and a plea. Mosison, we're still waiting on, and Stancil is a plea.
Yes, Your Honor. And this is
Ms. Harris.
Yes, Your Honor.
All right, raise your right hand for me, Ms. Harris. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down, ma'am. So, Ms. Harris, you're before the court for two cases. The first is 2025 CR 09401 for loitering and prowling. The second case is 2025 CR 09408 for theft by shoplifting. You're represented by Ms. MJ Tortorello with the law firm of Lister, Holt, and Dennis. Ms. Tortorello, what does she plead to the offenses before the court on each of her cases?
For Your Honor, for her first case of loitering or prowling, that'll be a NOLA plea. And for her theft by shoplifting case, that will be a guilty.
All right. So, Ms. Harris, on the case ending in 09401, loitering, you're entering a plea of NOLO. On the case ending in 09408, theft by shoplifting, you're entering a plea of guilty. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
And Your Honor, defense stipulates to the facts alleged on case number 2025 CR 09401.
All righty. Facts on 0948408. Ms. Bing, are you muted?
I definitely was. Thank you. On June 11, 2025, officers were dispatched to the Dollar Tree in Riverdale, Georgia, 0274, in reference to a theft. When police arrived, they made contact with the Dollar Tree manager, Miss Margaret Joyner, who advised that she had observed the defendant concealing items inside of her bag and walking out of the store without paying for it. When officers located the defendant and identified her as Brandy Harris, Ms. Joyner positively identified her as the offender that she had observed. Officers also searched the bag that Ms. Harris had with her and located the stolen merchandise, which was confirmed by Ms. Joyner. The state is recommending 12 months to serve, 130 days, credit for time served, balance probated, $500 fine per the statute, and an anti-shoplifting class, or a moral recognition course, and do not return. I've heard more positive things about the moral recognition class, so either one is fine.
That's fine. I'll do it.
I'm sorry?
I plead.
Okay. Ms. Tortorello?
And was the sentencing, for loitering, placed on record, Your Honor?
Yeah, I'm
No.
sorry, it was not. The case ending in 09401, where she is charged with loitering, it's 12 months to serve, 39 days credit for time served, balance suspended, and no new violations of the law.
That's
Okay, so the theft by shoplifting was 12 months to serve 130 days, credit for time served, balance will be probated, fine of $300 will be suspended, but
Oh, I'm sorry, go ahead.
no, what, did I get the fine wrong?
It was $500.
Okay, $500 will be suspended, and she can take a theft prevention course or a moral recognition course.
Okay, just really fast. I think that the fine can't be suspended per the statute, but I can defer to
Okay,
you.
I was wondering about that because some of them I know are not supposed to be suspended. Ms. Tortorello, thoughts on that?
It is, my understanding, Your Honor, that it's because it's, her second in life, it cannot be suspended. Because of that, Your Honor, my client is actually in a group home. So I'm asking for the court if, we could give at least my client 30 days to get on her feet, to get a job, so she could start paying the fine and get herself enrolled in a class. The last thing that I want for my client is for her to be set up for failure.
Yeah.
all I know is I'm in a group home.
I'm sorry, Miss Harris.
My client has just disclosed that now she doesn't know that if she's in a group home, so.
Which is likely because this is a long time that she was in jail. Do we know, did she have something else pending that kept her from coming before me?
My understanding, Your Honor, these are just the cases that she has in Clayton County. I don't see any other pending case.
Because this is a lot of days. Even for this being a subsequent alleged theft by shoplifting, this is a lot of days for her to have spent, and I didn't see her earlier than this. So I don't know if she was being held somewhere else, loaned out, but I need to, these are the kinds of things that I need to fix so that if it is my intent to give somebody 130 days, I'm fine with that. That is a well-reasoned and considered thing. But if it is that they are sitting in jail because we failed somewhere along the way, that is not all right with me. And so if we could just do a little research and maybe, and I'm not fussing at you, Ms. Tortorello, I'm bringing to the court's attention and to the attention of all of us involved that if there's a failing somewhere in the system, then I will push to have that addressed. But I gotta know what is keeping somebody in jail for this long before they get to me. Okay?
Yes, Your Honor. She's only in custody for the loitering case, Your Honor.
Okay, so there was something else somewhere.
It looks like she bonded out on her theft by shoplifting, but that she's only in here. Oh, she has a felony case, Your Honor.
Okay, all right. So see that I need to know because that then doesn't have me questioning why somebody would be in here. I'm fine with the sentence as it stands, but I just don't ever want anybody to fall through the cracks. And if I don't ask these questions, then if somebody comes before me and they have this amount of time and they haven't come before me prior to that, then I'm not doing my job.
And Your Honor, just to make clear for the record, she doesn't have bond for her felony cases. So is there any way the court would consider just time served for this case?
Yeah.
Thank you, Your Honor.
The only problem is with the $500 fine that's mandatory. I can give her like 90 days to pay it upon release. We'll suspend it as long as she's pays it within 90 days of her release from jail.
That's fair, Your Honor.
Okay, so on the case 2025 CR 09401, the NOLO plea, 12 months to serve 39 days credit for time served. Balance will be suspended as long as she has no new violations of the laws of the state of Georgia. On the case 2025 CR 09408, theft by shoplifting, 12 months to serve 130 days credit for time served. Balance will be suspended as long as within 90 days of her release from jail, she pays the amount of $500 as statutorily required for the offense.
And Your Honor, just to perfect the record, my apologies. There's a Brandy Harris and a Brenda Harris. She is only, Miss Brandy Harris is only in here for the loitering. But Brenda Harris has the felony charges. So I'm not sure if Your Honor wants to keep the sentencing that was read on record.
Well, then I'll give her the probation for that. But she can do $500 in money, or she can do 50 hours of community service. She doesn't have to make the decision right now. She can discuss it with her probation officer.
Yeah, I probably just gonna pay the fine.
Okay, but I'm giving you the 12 months to do that, but discuss it with your probation officer, and you can take the first month or so to get yourself back on track once you get out of jail, okay? All right. All right, Ms. Harris.
All right, we're ready with Mr. Brooks.
Okay.
One moment, Judge, please.
Sure.
Does Ms. Harris still have to take the anti-shoplifting or moral recognition course?
Yeah, let's do the shoplifting course.
Okay.
The anti-shoplifting.
Thank you.
Okay.
Your Honor, this is Mr. Brooks before you.
Mr. Brooks, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hands down. You're before the court on 2025 CR 00021 for a petition for revocation of probation for the previous case that you had before the court. You also have a case currently on the court's calendar, 2025 CR 09646 for battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4. The state has requested that that case be transferred to Superior Court for a felony determination because of a previous battery family violence. The court is going to sign that order. So the case that is the open case that's pending on my calendar will be transferred for the Superior Court. All right. So on the petition.
Your Honor, we're requesting a hearing to be set in about 2 weeks from now.
For the hearing? For the
yes.
petition?
Yes, Your Honor.
All right. Probation, we're going to, set a hearing for the petition for Mr. Brooks. Mr. Brooks, I caution you that telephone calls from the jail are recorded. Since the allegations include that you've had contact against the court's orders with the person who is the subject, who is the alleged victim in these cases. Please remember that you are not to have any contact. You could get charged with additional misdemeanors or felonies, and it may have a bearing on how this court views the petition in your case. So please don't reach out. I know we had this long, drawn out discussion of things when you came before me initially. So please don't do anything that's going to affect how the court looks at what your petition is. Do you understand?
Yes, ma'am. I'm not gonna reach out to her.
Don't talk. Just listen. Because that was the problem before. You did a lot of talking, not so much listening. And that's why we're back here. We clear? Probably if you had listened to half of what I said, you would not be standing back before me. All right. So we'll set a date for Miss Val. Is that what day we're talking about? For a hearing for probation.
I'll make a note for us to send notice, Judge.
Okay, so we'll send notice for the hearing date, for the probation revocation. But is my understanding, that we'll have that, within the next 2 to 3 weeks, hopefully. All right.
And Your Honor, will the state subpoena witnesses for that date?
Ms. Bing?
I'm so sorry. Will I be subpoena witnesses for which?
He's asked on the petition for Anthony Lamar Brooks.
Oh.
This is his second hearing before the
Yes.
court. He is alleged to have had additional contact with the victim in this case. He is of a violent or harassing nature. He has also been alleged to have been arrested for offenses before this court, and to have failed to comply with counseling as ordered by the court. So does the state intend to subpoena witnesses for the full hearing that he is requesting?
I believe so, although that could change, but I'm going to say yes for now.
All right. All right. So we'll, Miss Val will give you all notice of the Miss Kiera, send Miss Val a message. She may be away from her desk, that to give them notice of a hearing date for a petition hearing for Mr. Brooks.
Yes, ma'am, will do. And Your Honor, defense would like to challenge the transfer. We could also have a hearing on that as well. It is
On what basis, Miss Tortorello?
the facts alleged, just the facts alleged on the police report. I don't, just based on the facts that are currently alleged, I do not feel like there's sufficient enough for battery family violence. Therefore, I would like to challenge.
Okay, but that requires a determination of probable cause. If I find there's sufficient probable cause, then that would be the only basis for which I wouldn't transfer it. If it meets the statute, I'm fine with it.
I do not believe that it meets probable cause, Your Honor.
Ms. Bing?
I'm so sorry. Give me one quick second. I would, Portorello is saying that there's no probable cause for the arrest for battery family violence. I mean, the officer has reported that,
I don't want to hear the contents. What she's asking for is a probable cause hearing. What is the
Oh.
legal opposition to her requesting in state court after sentencing during a petition revocation discussion about the next case coming up, whether this court has the ability to determine whether there's sufficient probable cause such that this case meets the standard for the statute to be transferred for felony prosecution for a subsequent battery or family violence conviction.
Your Honor, the state would offer that because he is still an inmate. I believe he probably already had a probable cause hearing for the case to make it to state court.
he waived his preliminary hearing.
Okay.
So is the state going to be ready on the date that we have the petition hearing for a probable cause hearing in this case?
That's
Yes.
dependent on the availability of the officer, yeah.
Okay. State intend to subpoena?
We would have to. It'll be the officer.
All right, so 3 weeks out.
Thank you, Your Honor.
You're welcome.
Your Honor, may the state inquire though? So I believe he was represented by Lister and Holt when they waived the probable cause in the first place.
I know he was represented by Lister and Holt here, but I don't know what happened at the magistrate level.
He would have been appointed Lister and Holt at first appearance. And so they would have been the ones that waived the probable cause in the first place.
Yes, Ms. Tortorella's signature. Ms. Tortorella's signature is at the bottom of the waiver.
So now they come back and want a probable cause hearing?
Yeah.
Honor, at that
So
point,
Ms. Tortorello, you waived.
at that point in time, Your Honor,
Doesn't matter about the point in time, you waived determination of probable cause. There's no need for the court to go back and revisit something that was waived and which the magistrate court passed on. So for that purpose, I'm not having a probable cause hearing just to prevent him from having this case transferred. I will have a hearing on the petition, but not a probable cause hearing that was waived at the level where he could have had a full and fair probable cause hearing.
I understand state's argument, Your Honor, and I understand your position. However, in fairness, in this matter, that we have just been informed that my client's case is going to be transferred to Superior Court, and it is.
Ma'am, but for the fact that the magistrates didn't know his history, that case could have been transferred to Superior Court from the magistrate level. If the magistrates had reviewed his prior history as carefully as they wished to, and I'm not saying it's against the magistrates, but they could have transferred it as a felony at first appearance. We have that ability. We have the ability to upgrade or downgrade as we see fit as a magistrate when you're looking at somebody's history, and Mr. Brooks's history is substantial. And you waived the hearing, Ms. Tortorello, and so you can't waive a probable cause hearing where this could have been discussed and then ask for a probable cause hearing because you want to prevent a transfer under the statute to have this case adjudicated as a felony.
I was just doing it in the interest of efficiency, Your Honor.
It's not efficient for me to have another hearing that could have been held at the magistrate court level. And it is not efficient for me to now have to consider probable cause when the record meets the statutory requirements that there is a previous conviction for a battery family violence, probably with the same victim. And now there is a subsequent, when I told him to have no violent or harassing contact, and I really was wavering about that. It should have been no contact, but I believe it was for the medical reasons that involved the victim needing care. But because of the arguments made at that time, I said no violent or harassing contact. And then now we're back here with a subsequent arrest for the same thing, for the same person involving the same two people. And so I'm not inclined at this point to have a probable cause hearing that was waived at that level just for the purposes of preventing this case being adjudicated as a felony.
And has the state provided Your Honor with his prior conviction, a copy of the actual prior conviction, or
I have a copy of it, but they read it into the record the last time.
It's
You want to do that again?
Yes, please.
Case
Okay.
2025 CR 00998. Looks like it was resolved. Let's see. It was the incident date is January 23rd, 2025. And and it closed on March 18th, 2025 before your Honor.
And that was the date of conviction, Soldier Brooks?
It is.
Okay.
It appears also that on that particular case, his probation just closed on October the 9th of 2025. To clarify the sentence from March 18th, 2025 was 12 months to serve 180 days. And there were special conditions, and I believe the special condition was the contact that Your Honor spoke of.
All right, so what are we waiting on? This hearing will be continued for a full hearing where witnesses can be subpoenaed.
I think we have Frost left. But Your Honor, Mr. Brooks is actually going to handle that, and I think that's my last case. Could I be excused, please?
Yes, ma'am.
All right, thank you so much. Lovely to see you.
All right.
Your Honor, this is my last case as well. May I be excused?
Yes, ma'am. Thank you.
Thank you, Your Honor.
All right, so 3 weeks, I think, is what I asked for Brooks.
3 weeks, yes.
Yes, ma'am. And Ms. Val is working on it.
Yes, ma'am. Thank you. Ms. Arnold, I've done the pages.
I'm gonna drop them back off, Judge. You can set them to the side for me, please.
All right, thank you, ma'am.
And I guess, I don't know, Miss Bing's still on. Almost had my call, but thing went off.
No.
Wait,
Can I do another clear?
Your Honor, I see 3 cases remaining. That's Lasanya McConnell, Leroy Frost, and Monfiston Emmanuel.
Yeah, Emmanuel Monfiston.
I heard that you were handling Mr. Frost. We can go ahead and do that through a plea.
All right.
All right, I'm ready. Yeah, as soon as they appear, I swear I'm in. So that's all I'm waiting for.
Bring Frost when you get a chance. And just, Mr. Brooks, so you're just avoiding it. So we will agree to pay the amount on the invoice as restitution. I'm hoping that since
I'm sorry, Mr. Lynch, you need to speak up a little bit for me.
I'm sorry, I just want to explain to Mr. Brooks that the victim submitted an affidavit, and they had asked for restitution. We'll agree to pay that amount. I'm hoping it's a suspended sentence after payment, since I didn't see any other condition.
Okay.
Or probation suspending after payment of the restitution, if that's
No
acceptable.
objection. No objection to that.
All right, and I believe there's someone from, or there was someone from the complex here.
She's still on, Your Honor. Miss
Thank you for your patience, ma'am.
Aye.
All right. All right, Mr. Frost, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
All right. Yes.
Okay. Sir, you're before the court on State of Georgia versus Leroy Frost, 2025 CR. You can put your hand down. 09360 for criminal trespass. Mr. Lynch is representing you. Mr. Lynch, what is your client plea to the offense before the court?
Complete guilty, Judge.
All right, by entering a plea of guilty to criminal trespass, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, present evidence and testimony on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yeah.
All right, factual basis recommendation, please.
Yes, ma'am. On September the 19th, 2025, officers with the Clayton County Police Department responded to 5206 Norman Boulevard in reference to a property check. Officers received a call from the property owner, Ms. Elgova, who advised that she got a motion alert through her Ring system. When she accessed the live feed, she was able to identify or provide to the officers a description of the individual who came through the window and opened the front door. The individual was identified as Mr. Leroy Frost, the defendant. This all occurred here within Clayton County. The state's recommendation is 12 months to serve, 27 days. He'll be credited with time served. The balance is to be probated for him to pay restitution in the amount of $640. And additionally, he's to stay away from that location for 5206 Norman Boulevard, Atlanta, Georgia, 30349.
Okay, is there a entity to whom the check should be made out to when he pays the restitution?
The address that I have on file and Miss Elkaba, is it the New Jersey address you would like?
Yes.
Okay. It should be mailed to Corina. That's Corina. Elgaba, Elegba.
Elegba.
I'm not saying it right. Forgive me. Say it again.
It's Elegba, right, Miss Eleg? Isn't it Miss Eleg? Okay.
Elegba. Forgive me.
I didn't want to interrupt, but just for if he's paying restitution through probation, wouldn't he pay it to the probation office and they send it over?
No, what he's clarifying is for the record who it gets sent to, because once probation gets it, they turn it into a check or whatever, however they send it.
I understand.
They don't directly pass his cash off to the next person.
Okay, I understand.
Again, that's it should be made to Corina Elegba.
Mm-hmm.
All right. At fifth address, the mailing address is 59 Pilgrim Road, Short Hills, New Jersey, 07078. That's 59 Pilgrim, Pilgrim Road, Short Hills, New Jersey, 07078.
All right. So I'm going to accept Mr. Frost's guilty plea, 12 months to serve, 27 days credit for time served. Balance will be probated for him to pay restitution in the amount of $640 to Corina Elegba as stated. Upon payment of the full amount of the restitution, this probation can suspend.
And Judge, Thank you. The only thing else I would ask is if you would consider waiving probation fees so he can concentrate on getting the alleged the victim here compensated.
All right, Mr. Frost, you got a job?
No,
Are you able to work?
yes, I have my social security and I have my license.
Okay. All right, I'll suspend supervision fees.
Thank you, Judge.
And he's not to go back onto the location at 5206 Norman.
Yeah.
All right. All right, Mr. Frost. Thank you.
You're good to go.
All
All right.
Your Honor, I'm ready on, with Ms. McConnell's case.
All right, I'm ready.
And if Ms. McConnell, you can unmute yourself, please.
I'm sorry, I was on the wrong calendar. Who's calling? 1 second. All right, 1 second. Let me All right, Ms. McConnell, thank you for your patience. This is State of Georgia versus Lasagna McConnell, 2022 CR 06698. You're represented by Attorney Tortorello, who is with you in court by video. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So you're before the court on simple battery, family violence, count 1, simple battery, count 2, and cruelty to children, count 3. Ms. Tortorello, what does your client plead to the offenses before the court?
Yes, Your Honor, for count 1, simple battery, family violence, she's pleading guilty under the First Offender Act. My understanding is that count 2 will merge and count 3 will be null prost.
Okay, by entering a plea of guilty to count 1, count 2 will merge, count 3 will be null prost. You give up the right to have under first offender, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Ms. McConnell?
Yes, ma'am.
All right. Factual basis recommendation, please.
Your Honor,
This is on the arraignment calendar.
I'm just Your Honor, the state's gonna move to null process matter. I'm embarrassed to read the facts to the court.
Thank you.
Now I gotta know.
It's silly. I would admonish Ms. McConnell to not do what she did previously. The facts essentially was she and her baby's father got into a argument because she slapped a sandwich out of his hand, and because he changed his mind about wanting the sandwich.
Okay, Ms. McConnell.
But she has no criminal history, and so I'm not prosecuting this.
I got you. And thank you, Mr. Brooks. Ms. McConnell, co-parenting is hard. It is. And being in a relationship is hard. But you got to remember that as frustrating as it gets, everything that you do and every behavior that happens between you and the father of your children, they are watching, they are absorbing, they are hearing. There is nothing more that you can do to destabilize a child and make them an adult with problems is to have them grow up in a household where they never know what's going to happen. Like it's volatile. Like we don't know from one day to the next whether we're gonna be tucked in at night or and sleep peacefully, or where we gonna have voices raised here, people arguing over silly stuff. It just really is not worth it. If y'all are not able to get along, then go ahead and separate and co-parent. But
I did that.
you did that. That's what
Yes.
I'm saying. And during the co-parenting, because y'all gonna have to be in each other's lives for a while. This is what I suggest.
Could I say something? The only reason we can't co-parent because he shot me, so that's why we don't have any conversations at all. So I only talk to his mother and his father right now.
That
So
happened after this?
Yes, ma'am, but I didn't want to press charges or anything because I already know I had a case against all this, so I didn't want to lose both kids to lose both of the parents. So I just didn't say anything.
Yes, Your Honor.
Oh
They've
my
been co-parenting. My understanding is the father is not legitimized, but she is still allowing her children to see their father, and grandma has been the third party transport for visitation.
With somebody who shot you?
Yes, ma'am.
Okay, let me just say some things and you don't have to respond in any way. But if the contact is because you are afraid, then that means that nobody's safe. If you allow the contact because you are afraid not to, nobody's safe. If his parents are pressuring you knowing that this happened, nobody's safe. If he would do something like that to the mother of his children, you're not safe. Even having this type of contact with him, you're not safe. When there's this is October is the Domestic Violence Awareness Month. And so I've tried to do as much as I can to always be present of mind about the situations that can lead to volatile contact between parties. And there's this guy who has this thing like on the internet where he talks about red flags in a relationship and the things that you see immediately where people think, oh, I'm going to just laugh it off and suck it up. And it turns out to be a red flag about future behavior in the relationship. And what I say to you is, you need to always be mindful to protect yourself and your children. If he has not legitimized these children, you are the only legal parent. And you do whatever is necessary to protect yourself. Do not let anybody pressure you. Oh, well, he's the father and he got to see his kids. A person who would shoot the mother of their children is not a good father. I'm gonna just tell you that right now. If you don't protect the other parent of your children to the highest and best because you know what it would mean to your children to not have them, then that is not a good person. And if you need to reach out to any organization or any nonprofit that works in the domestic violence space, do that and protect yourself at all times. Do you understand me?
Yes, ma'am.
Okay. Whew.
It's just like I get like threats and stuff, so it's really basically a lot with him. So I'm just trying to be calm in the situation because it's always something, and I don't want anything else to go wrong or anything. So I just been trying.
I'm gonna just let you in on a little secret. You cannot appease people like this. Even when you're calm, even when you're trying to make sure nothing goes wrong, it is not because it is not you. These are not outside triggers. These are things that he's dealing with. And so he will always find a reason. There is nothing you can do to keep him calm in the long run. There is nothing you can do to appease him. There is nothing you can do that he will not act out in certain ways because this is who he is. This is who he has grown up to be. This is who he's been trained to be. And if he is threatening you, you need to make sure you document it with the police. The best thing you can do also is for legitimation purposes, go through the Superior Court. Have them write out the steps that are necessary to make sure that you all can co-parent safely. But ma'am, for any and all things, never meet with him alone.
Yes, ma'am.
I don't care what he says. And I don't care what anybody says about me telling you this. There have been too many instances, even recently, where it's popping up on my news feed where this person has gone missing and then they find out it was her intimate partner. That person has gone missing and then they find out it was their intimate partner. 5 that I can think of in Georgia in the last 6 months alone, and all Black women. Never, ever, ever meet with him alone. Always document where you're going. Always let somebody know if he contacts you and he's threatening you. Because if you keep that information to yourself, if something happens, nobody will know where to look.
Your Honor, I would additionally offer her, you should consider pursuing a temporary protective order in the county that you reside.
Yeah. So if you reside in Clayton County, you would do that through the Magistrate Court of Clayton County and get a protective order. And they also will manage things like child support or visitation or anything like that. But generally, they will do their best to keep the separation between the parties so that you're safe. But I'm just telling you, Ms. McConnell, this is not a situation that you can manage by being good or being nice.
Yes, ma'am.
That, you know, they will find a reason. I've heard of women say that, you know, I made food and it wasn't hot enough or it was too hot. I mean, who controls that? Nobody. You know,
Yeah. It's a lot. I've been trying to keep calm because it's just been so much, but I understand.
what I'm going to do is I'm going to ask Ms. Hemphill, do you have some information about the domestic violence groups, the Partnership Against Domestic Violence, or I think there's another one that's working in this space that you could provide to Ms. McConnell?
Yes, ma'am.
All right, I'm going to put you in a breakout room with Ms. Hemphill, and
Okay.
she's going to provide you with this information. Also, if you wish to do a temporary protective order, you would do that through the Magistrate Court of Clayton County. You would just contact them, and they would give you a time to come in, and they would walk you through the process of doing that. But Ms. McConnell, please, if you have never listened to anybody, don't ever, ever, ever meet with him alone.
Yes, ma'am.
Ever go anywhere and not let anybody know where you are going.
I learned my lesson. I have.
Always keep somebody like a lifeline that says, hey, I'm headed to work. Hey, I'm in my car. Always. If you have somebody that you trust and you love and they can you can share your location with them, do that.
Yeah, it's my mom. She's been watching.
And
So,
I do want to stress to my client, I apologize, Your Honor, that she does not have to continue having these visitations with her child, especially if her the alleged victim here is not legitimized. He has no rights. So you don't need to keep doing the transfers.
yeah, but my fear, Miss, and I know that's correct legal language, Miss Tortorello, and I'm thanking you for providing that. My fear is I didn't want to suggest abruptly stopping something that might put her in jeopardy.
Yes,
So,
Your Honor.
but I'm going to put you in a breakout room with Miss Hemphill, and Miss Hemphill is going to give you some information that may help you kind of walk yourself through this space, okay? But as I said to you earlier, and I mean this, there's nothing that you can do that appeases this type of behavior, because that behavior is going to happen whether we're good, whether we're bad, whether we're nice, whether we do exactly what we're told to do or nothing at all. You understand?
Yes, ma'am.
Okay, so I'm going to put you in that breakout room, all right? And I'm going to pray for you, Ms. McConnell, and hope everything goes better for you.
Yes, ma'am. Thank you.
You're welcome. So, Ms. Hemphill, I'm putting you and Ms. McConnell in breakout room number 5. Thank you, Mr. Brooks, for that. And when you finish speaking with Ms. Hemphill, you don't have to come back to the main room, okay?
Yes, ma'am. Thank you so much.
All right, take care of yourself, Ms. McConnell.
Judge, she'll need a set aside also.
Okay, go ahead and do that for me, please. Send it to me.
Mahone.
All right, who we got next?
Yes, sir. Yes, sir. Mr. Brooks, we're gonna, I asked him to bring out Mr. Mahone or Mahoney for a negotiated plea. Are you gonna be handling that?
You said Mahone?
Yeah, Mahoney or Mahone, I think,
I don't have that, but give me 2 seconds. I'll
he's
have
on the jail calendar.
just a second. All right. Just one moment, please.
No problem, Charles. I just wanted to, point out that, we're in agreement with the recommendation. It's the minimums. I just wanted to point out that, the time that it says he served, I think was given to us when he originally was on the jail calendar, and then he was loaned out to the hospital. So it's a little bit more time than that, but that's the only thing.
Okay.
I understand. Let me, Yarn, if I can step away just to grab that file.
Yeah, we'll be right back.
At the court's pleasure.
We're ready as well.
The court will be back in just a moment.
Proud for you.
Ms. Powell.
What you need from her?
Ms. Powell.
Oh, I'm sorry. She was in here talking to me, Mr. Brooks.
Okay. I was gonna inform her that I'm preparing to set aside for Your Honor.
Okay, thank you.
For McConnell.
If you just send it to me, I have my tablet up and I'll sign it. All right. Who's this gentleman?
This is Mr. Mahoney, or is it Mahoney?
Okay, so is it Mahone or Mahoney?
Speak up. It's hard to hear.
Mahone.
Okay, Mr. Mahone, raise your right hand for me.
Raise your right.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So, Mr. Mahone, you're before the court on 2025 CR 08374 DUI less safe. You're represented by Mr. Lynch, who with the law firm of Lister, Holt, and Dennis. Mr. Lynch, this is the gentleman that was on loan to the hospital for a while.
Yes, Your Honor.
Okay. All right. What does your client plead to the offenses before the court?
Judge, I believe it's a 1-count accusation and it's going to be a guilty plea.
All right, Mr. Mahone, by entering a plea of guilty to DUI less safe, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yeah.
All right, factual basis and recommendation, please.
Yes, ma'am. On August 20th of 2025, officers with the Clayton County Police Department responded to the area of Battle Creek Road and Jonesboro Road regarding a traffic collision. Officers made contact with the drivers involved, identified Mr. Kenneth Mahone as one of the drivers. During the course of the encounter, officers did make observations of impairment of Mr. Mahone. Conducted a DUI investigation, which confirmed those. Or excuse me, they did several of the field sobriety evaluations to include HGN, and did conduct a PBT, which confirmed their suspicion. So officers ultimately arrested him for DUI less safe. They did read implied consent, to which he refused. This all occurred here in Clayton County. State's recommendation to the offense is 12 months to serve, 28 days, to which he'll be credited with time served. The balance is to be probated. He's to complete a substance abuse and evaluation and treatment should it be necessary. Partake in no drugs and alcohol during the course of probation. Submit to random testing. He's to complete 40 hours of community service and pay a $300 fine, as well as complete a DUI risk reduction course.
And that is basically, we agreed to, but not to quibble, but I think that he's been in custody since his arrest, and I think that's longer than 28 days. And I think he would be entitled to that.
Absolutely. Absolutely. If he's been in continuous custody, then that's absolutely right.
Because he was on loan to the hospital, but he was never released from custody. Is that not accurate, Judge Hayward?
That's my understanding. I didn't release him, but the jail is doing all kinds of things nowadays.
So I guess we just ask for credit since data lockup,
Yeah, I'll give him that. Credit since lockup. So, Mr. Mahone, sir,
Yes, ma'am.
you can't be on the road with impaired to the extent that you can't properly drive, because this was an accident. Somebody could have been killed.
Not to minimize that there was an accident, Judge. I believe it was a parking lot type of collision. Not that that changes anything, but
It's still an accident, Mr. Lynch.
I know. I know.
Thank goodness it happened in the parking lot instead of on the road.
Well, yes, Judge, that's true.
All right, Mr. Mahone, I'm going to accept your plea. 12 months credit since the date of lockup. Balance will be probated for you to take a substance abuse evaluation, to have no alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs. You're to do 40 hours of community service, a $300 fine, which is going to be closer to probably $800 with the surcharges, and a risk reduction course.
And Judge, that we would just ask the court if you might consider waiving probation fees for at least the first 3 months so he can kind of get on his feet. He does have some significant medical expenses, my understanding.
For the first 3 months, Mr. Yeah, first 3 months, that's fine.
Thank you, Judge.
All right, and Mr. Monfiston, did you need anything else from me from Mr. Mahone?
No, Judge, he's good to go.
Thank you.
I think Ms. Tortorella is finishing up with Mr. Monfiston this time. Judge, she's finishing up with Mr. Monfiston.
Solicitor Brooks, I sent you a chat. Were you able to see it?
I'm sorry, say that one more time.
I sent you a chat. Were you able to see it?
I am now. Okay, let's see. Okay.
Thank you. I'll just wait for your response.
Are we ready on Murphy Stone?
I'm replying right now, Your Honor.
Oh, okay. I'm sorry. I thought I'd missed something, but okay. I'm ready whenever y'all are.
I apologize, Your Honor. Thank you for your patience. Your Honor, we would like to be heard on bond for Mr. Montfiston's case. If quick bond hearing, Your Honor.
Date?
We're not prepared for a bond hearing. We have to make contact with the victim so she has ability to be heard.
Yeah.
Okay.
Okay. Was there a reason why he was denied bond downstairs? 1710-1, 1761? What was it?
It's not. He hasn't been denied bond, Your Honor. He has a total of $5,000. He cannot make that. He does have an ICE hold, but he's aware that if he's aware of the risks if he's able to bond out. His intention is to stay here. He's been trying to seek asylum, Your Honor.
Okay.
But the purposes of efficiency here, we'll just, can we have, I guess, if the state cannot do a bond hearing today, if we can reset it for when is the next jail calendar, Your Honor? I'm not aware of. So
we do it every Tuesday unless I have a conference or something.
Can we reset it for next?
That's up to Miss Val.
Yes, we can put it on next Tuesday. Who is it? What's the defendant?
Mr. Monfiston, Emmanuel Monfiston. He's on the
Yeah.
jail calendar.
Yeah, he can be put on the jail calendar for next Tuesday. Is that enough time for the state?
I believe it should be. We're gonna make contact with Miss Pascal this evening probably.
Okay, thank you. And my client will be pleading not guilty and waiving formal.
All right.
Today,
Okay. Next Tuesday, the 28th.
Thank you.
10/28. That's at 10 o'clock, correct?
Yeah.
Yeah.
All right. Thank you.
Thank you.
All right. So that, unless I miss my guess, that should conclude everything we have going on today.
Thank you, Your Honor.
All right. Thanks.
Thank you, Your Honor. Ms. Hemphill, if you would come see me about this last matter.
Yes, sir.
All right. Thank you.
All right.
All right. Thank you, Your Honor.
All right. Thank you.